Hi, welcome to Property Law 101. I'm Sara Bronin, and I created this series to help you understand a little bit more about property and property law. We consider four fundamental questions in this series, and today we are talking about the fourth question, which is holding an interest in property, and specifically the lease. So leases are a very old type of property interest going back to feudal times. Traditionally, leases were considered to be a creature of property law. What that meant was that the lease was simply about the right to possess and nothing more. The thought was that the tenant in possession would be responsible for maintaining the land as if the tenant were the fee simple owner. This might have worked when, in an agrarian society, the land that was leased was agricultural in nature, and most people knew back then how to manage land. However, as society evolved, people started to live in more urban areas, and the type of work that people did became more diverse. It became untenable to require tenants to be responsible for maintaining and managing the leased premises on their own. So the 1960s was when you saw many jurisdictions taking action to modernize the concept of leases and to protect tenants from the assumptions of the past. Since that time, both courts and legislatures have treated leases as instruments which have some property law and some contract law elements. So from property law, we'll start there. From property law, we get the idea that a tenant has a possessory interest, which is protected from interference. We also incorporate from property law the principle of waste, which means that tenants cannot do something to their properties that would affect the landlord's interest. From contract law, so the area of law which leases have evolved to encompass, contract law, it's been applied more and more to leases. We get certain formalities like the statute of frauds, which means certain leases have to be in writing. The prohibition on unconscionable leases and the implication of certain warranties also come from contract law. There's also an implied duty to mitigate damages, which we cover in a video about a case called Summers versus Crydell. From contract law, we also get remedies such as damages, which operate alongside the injunctions and forfeitures of property law. Landlord tenant law has evolved not just to accommodate contract principles, but has also experienced a substantive evolution toward greater and greater protection of tenants. These protections, everything from the mandatory implied warranty of habitability to smoke detector requirements and other default rules, reflect what some consider to be paternalistic tendencies. Like many special kinds of contracts, leases have default rules often dictated by the legislature. The default rules are often symmetrical. So, for example, the landlord's notice rules are often the same as a tenant's. But many default rules are asymmetrical and, as noted, increasingly pro-tenant. Many default rules established in state law cannot be deviated from, particularly in residential leases. So, for example, lots of states require landlords to comply with building and housing codes, make certain repairs, keep common areas clean and safe, and maintain wiring and plumbing in good working condition. They may also require landlords to keep security deposits in an interest-earning bank account. Importantly, many states will not allow landlords and residential tenants to bargain around eviction laws. Otherwise, unscrupulous landlords may put in the fine print that tenants can be tossed onto the street without due process at all, and perhaps only for mere minor infractions. That said, some default rules can be deviated from. So, for example, state law might indicate that a landlord is expected to deal with trash disposal, but may still allow parties to negotiate around that. In negotiating a lease where there is a deviation from default rules, or really where there is any important clause, the parties may wish to put that clause in bold or in color, or put places for initials that indicate that the parties discussed the matter. The more sophisticated the parties, the more likely they are to contract around the defaults. Courts will enforce these asymmetric entitlements as long as they don't violate the law or, drawing from contract law, are not unconscionable. So you might be asking why we have all of these default rules. Most of them seem to place burdens on the landlord. I think that's because in a modern society, we assume that the tenant is less capable of dealing with some of these issues than a landlord. Tenants will not necessarily know how to maintain a plumbing system or ensure a stairwell is well lit and safely constructed. There also may be third-party effects that we are worried about. For example, if there is no smoke detector because no specific person is responsible for installing one, an entire neighborhood may burn down. I will conclude just by mentioning that there is a trend among landlords to rely on form leases, often found on the internet. This may be a cost-saving measure which addresses basic needs. How many tenants really look at these leases anyway? On the other hand, mass-produced forms are not always enforceable, in part because they are generic and not tailored to the rules of the state. With that, I will leave it there. I'd love to hear from you, whether on Twitter or through my website, and I will see you next time.